Hi, it's Joanna Toch with the Family Law Cafe podcast. Today I've got Lissie Squire with me. And Lissie, tell us about you. What do you do?
So I am a solicitor and director at Britain & Time Solicitors.
Okay.
There I specialise in private client law. So that's your wills, powers of attorney, trusts, tax, probate, all of the funnest topics that we love to talk about.
All the sexy
of course.
stuff.
All of that, exactly.
Okay. And where is Britain & Time based? Where is it?
We have two offices.
Yeah.
One down in Brighton and one in lovely London, where we are now, in Mayfair, just near Berkeley Square.
Okay. And so what was your route into the law? What's your background?
So I studied law when I went to university. So I went to Southampton Uni.
Yeah.
Studied, and to be honest, by the end of my degree, I absolutely hated the idea of becoming a lawyer. I thought, no way, that is not for me. It's just not my bag. So I went back to Exeter, which is where my parents where I grew up, where my parents live now.
Yeah.
And kind of floated around a little bit, wasn't quite sure what to do, and I just felt the law tugging me back towards it. So I thought, maybe needed a break, and then I wanted to get back into it. Do
you mind if I just ask, why were you fed up with it after doing your degree? Because I'm sure the people that watch, and often people will contact me and say, oh, my daughter's doing law, how should it go? So what was it that put you off? You must have liked it before you started the degree.
I have to say, I think it was probably more the fact that I was just working so hard towards the exams at the end of my third year.
It's a bit burnt out.
I was just burnt out, exactly that. So I was working all day, every day, lots of exams to prepare for, and I was probably getting about 4 hours sleep a night. So I wasn't being conscious of my own boundaries and looking after myself in the right way. Yeah. And that's so important in this industry,
100%
as well. It's so important to have that self-care as well as the dedication to our clients.
Yeah.
So I learned that lesson early in my career, thankfully. I went back to Exeter, floated around a little bit, tried a few different things like retail and things like that, and just thought, this is just not working for me. I need a challenge. I need something that really pulls me in and really challenges my mind. Yeah. So I became a paralegal down in Exeter. So working alongside the solicitors. Yeah. And I was doing residential conveyancing. Yeah. And that was, again, not the sexiest area of the law.
Well, it suits some people. I'm sure there's people that absolutely love doing that.
Absolutely.
Yeah.
And it does
not me,
exactly
but,
suit some people.
Other people.
Exactly. But the most interesting thing I did was help transfer a property that was held within a trust.
Okay.
So I helped the private client team at the firm I was at there with those transfer documents because I was working in property. And that was the most interesting thing I did the entire time I was there. I thought, I think I need to think about this area of law a little bit more and really explore that. Yeah. So what I did was every move I made after that in my career was to get me to private client law, but also to qualify and have trained in London. That was really important to me. Right. Because at that point, if you've trained in London, you've got cream of the crop, you've got really good training, and then when you move to maybe a regional firm, you're very well qualified within that. Yeah. That was the idea. So I worked hard. I worked for a couple of years at Freshfields in their knowledge team. When I moved up to London, I worked at Stevenson Harwood for a bit. And then I was very, very lucky to land a training contract with a wonderful firm in London called Morris Turner Gardner. And they are a kind of boutique private client firm. Yeah. Really specialist in what they do, really fantastic. And that training was amazing. So I was there for 2 years, did my training, and at that point I was looking at moving to a regional area once I was going to qualify. And I found Britain & Time Solicitors. It was a very small firm at that time. I was messaging back and forth with Paul, our wonderful managing director, and we just got along like a house on fire. He was really sweet because he let me come down to Brighton for a interview on a Saturday because I was working full time in London. He thought, you don't want to be taking time away from work. I completely understand that. Let's meet on a Saturday morning. We did. We talked for hours. Again, got on so well. It was an amazing meeting. And we thought, you know what, this is a match made in heaven. We got to do this. Okay. So that's really how I got into Britain & Time as well. I've given you a lot more than you asked for.
But it's really interesting. And, paths into law and deciding, what you want to do. I mean, when I started with crime because I wanted to be a barrister. I didn't even think about, it wasn't even the law so much. I mean, when I started my law degree, they always ask you this question. I don't know if you had this, what is a contract? Thinking it's a really simple thing. I'm like, oh, I don't really know.
I don't really get it, actually. I didn't realise. I didn't understand.
When you get on a bus and you get a ticket, that's a contract. You're buying a ticket to get, okay. Yeah. I was so dumb. I was like, honestly hopeless. And, good, hear me. And I didn't really know much about law. I just seen barristers on TV and thought that would be quite a cool thing to do. That looks good. And then I became a barrister. I was in a really good set of chambers, and I always wanted to be a defence barrister, but they just happened to specialise in prosecution. Like, okay, that's not what I was planning. But I did do crime for about 8 years, but then I was doing family and other things, and you get to know what you want to do.
Yeah,
but until you do it, you just don't know, do you?
No, exactly that. Yeah. Exactly that. I mean, like I said earlier, I dipped my toe into private client law within that transaction that I mentioned. Yeah. But when I was working at Freshfields and Stevenson Harwood, I wasn't even looking at private client law. I was looking at finance. Right. So I was in the debt capital markets and securitization team at Freshfields. So it was like international bond deals.
Which lots of people would think would be amazing. Yeah.
But exactly, some people would think that was incredible. Yeah. For me, I thought, I don't really want to be working for these big banks, just making more money for them, to be perfectly frank. Which I know gives you a little insight maybe into my political views as well.
Yeah. And so what was drawing you then to what you do now? So just set out what you cover now so people can understand.
Of course. Yeah. So what I cover now is wills, lasting powers of attorney and general powers of attorney, putting trusts in place, helping the management of trusts during their lifetime, and also helping to close down trusts as well. The probate process, which is a lot of tax related stuff. Yeah. Got to report your estate to HMRC, possibly pay inheritance tax, and then make an application to the probate registry to get basically the court's permission to deal with someone's estate once they pass away. Yeah.
I mean, you're helping a private client, the clues, in the title, you're helping people rather than organisations. So before you were trained to do that. But what you were doing is quite high flying, wasn't it? Because you were helping to make, capital markets and finance or whatever. And trust is pretty legal, isn't it? It's not, most people don't really understand. And I've actually read judgments where judges describe trust differently: common intention trust, constructive trust, resulting trust. I don't know, there's many different trusts.
There's and types of
sometimes they call them different things. As a family lawyer, sometimes I'm in a case where trusts are a feature, and then there's someone from the Chancery Bar and they see trusts in a different way. And it's really quite interesting. So what drew you to that? I mean, because I'm just wondering if it was the mixture of people and sort of quite demanding intellectual stuff, but I don't know. I'm just guessing.
I think you hit the nail on the head there. That's exactly it. Yeah. It's more about helping people. That's what I really want to do with my career. That's what means a lot to me, and that's where I get my fulfillment from, is supporting people in those situations who maybe are untangling something that's really, really complicated. For example, I've helped a gentleman who he's just a beneficiary of the trust, so he's not the trustee, so he's not the person making the decisions, but the reason the trust was put in place is no longer really applicable, and so he's trying to reason with the trustees who do have all of the power to help unwind it and really just make sure that works for him. So there's an interplay of exactly what you said, which is helping individuals sort out complex matters which they couldn't sort out themselves. Yeah. And that technical legal
You're doing something really useful with your brain, aren't you, in a way?
Exactly.
I'm guessing.
Exactly. That's so fulfilling.
So for people that are listening or watching, what is a trust?
So a trust is, at its crux, is a legal relationship.
Yeah.
That's really all it is at its absolute simplest form.
That tells me loads.
I know, that tells you so much, doesn't it? It's so helpful.
It's a legal relationship.
A legal relationship. So you've got three people who are involved in the trust at different times, or three parties. So you've got someone called a settlor, and that's the person who used to own the assets that are now in the trust.
So we have an asset. What's an asset?
An asset can be anything. It can be cash. It can be a property. It can be shares. It can be an item. I could take this. There's something on this table, this lovely little hedgehog who's adorable.
So here we've got this asset.
That's an asset.
Lizzie, do something. Put this hedgehog into trust.
Into trust. So if I'm the owner of the hedgehog to begin with, I then give it to you.
Okay.
And
who am I now then?
You're going to be the trustee.
I'm going to be the trustee.
So the legal ownership of the asset passes to you.
Right.
So you now appropriate that asset. So you take it into your possession.
This is my asset.
It might be if it's property registered in your name, shares might be registered in your name. But if it's cash or what we call a chattel, so an item, a personal possession, that can be transferred just by handing over or transferring to a bank account if it's cash. Okay, so then I'm giving you the asset.
Yes.
But I'm giving that to you on a condition.
Right.
I'm saying, Joanna, hold that, but you have to safeguard that.
Right.
You have to protect that asset and you have to use it for the benefit of, I don't know, my children.
Okay.
Okay, so you have to maximise the value of that
trust.
for
so
them.
you were drawing up the trust for the hedgehog trust.
The hedgehog trust.
The hedgehog
Love that
trust. Name. I'm the trustee.
Yeah.
And we have Ben who's filming us. And is it for his benefit?
It can be for his benefit, yeah.
So
he's not my son, but that's fine.
Yes, he's not your son. But let's say I'm holding this hedgehog on trust for Ben.
Yes.
And would there be conditions for me as a trustee?
So as the settlor, I can decide those conditions.
Yes.
Yeah. Within the law, there are certain responsibilities and obligations that you will have within that relationship.
Which is understandable because I've got this valuable hedgehog and if I were just as a trustee to run off with it, there's got to be some general legal obligations.
Exactly.
Yeah.
Exactly. Okay. So that's you benefiting from the trust without my permission.
Yes.
So the law has a lot of default provisions around that relationship.
Yeah.
But this is why it's so good to have a trust that's actually written up and on paper.
Yeah.
Because I can change those default provisions within my own trust document.
So are there any trusts that are not written?
Yes.
Oh,
lots of trusts are unwritten.
What are they called?
Lots of trusts. They can be called lots of different things, unfortunately. It might be a bare trust.
Yeah.
It could be called an implied trust.
Yeah.
And
we're talking BARE, not a bear. Yeah.
BARE.
No, because we've got a hedgehog.
No, that's right. No, that's very true.
So a bear
actually.
trust
a
being,
bear trust.
it's kind of what it sounds like, a bit of a naked one. There's nothing much to it.
Nothing much to it, but it's also
simple.
It's a bare trust if it's really at its simplest form. Again, it's whilst you hold the asset, there's nothing stopping, say, Ben as our beneficiary claiming that asset.
Yeah.
So that's something, if he has what's called a vested interest. Now, what that means is he can say, Joanna, give me that hedgehog. It's mine.
Yes.
And there's nothing
I can do because it's a bare trust.
You're not allowed to say no, basically.
Yes, right.
Because he might be over 18.
Yeah.
Mental capacity isn't an issue.
Yeah.
There's no other conditions attached to that situation. Yeah. And so when it's a bare trust, it's simply being held.
So if Ben's in his right mind, he's over 18, and these are general legal points, aren't they? I mean, because you can imagine if someone had some mental ill health or they were 16 who can deal with a hedgehog. So he could take that on a bare trust. And what's the other one?
Implied. So implied might be in a situation. It might be construed as a trust. So this is where maybe like resulting and constructive trusts come in. Where maybe it's not written down, but the law has to imply a trust into that situation to say, actually, what happens is this or that. Because that's what's most fair or equitable.
And I'll dive in there. So unmarried parties, so man and a woman, let's say, bought a property together, they'd never married, they might have had children, been in a long relationship, and maybe that's a bad example because usually if the beneficial interest will follow the legal interest, so usually it follows that, but there can be talk about trusts in those cases. Those cases are dealt with under, trusts law, not
Exactly.
Not matrimonial law.
Yeah,
and
exactly.
That's a massive area in family.
And it's only becoming more prevalent with really the demise of people getting married.
People not
fewer and fewer people are bothering.
And they're putting themselves into a really complex area of law.
Yeah.
But so we were talking about implied trust. And implied, it's when I suppose people might believe it to be true without any written evidence. Is that what?
Without an agreement.
Without an agreement.
Yeah. So it might be in that exact situation. There's been history of trusts or really the equitable interest, the beneficial interest in a property, being different from the legal interest in a property. Perhaps where you've got one person in the cohabiting relationship who's the legal owner of that property, but the other person who maybe has given up their career to raise the children, or they have invested in the property in some way. For example, they've paid for renovations or they've started to pay the mortgage or pay contribution towards the mortgage, that kind of thing. That's where the legal interest and the beneficial interest diverge.
Yeah.
So the legal interest is what's registered on the land registry itself.
Yeah.
And the beneficial interest is who really owns that property and has a right to the proceeds.
Yeah. And just
very
stopping right there, legal and beneficial. Sometimes I explain that by saying kind of comes from days gone by when, people would, prostrate themselves in front of the king and say, look, although that person has a legal interest, really it's my wagon, they just saying they own it. Yeah. And the king would say, yeah. So you have the beneficial interest. And it's not the same in every country. But in England, we have legal and beneficial interest. What's on the legal title and the beneficial interest being what might really be true. And it's discretionary, isn't it? You don't always know who's got the beneficial interest. And this is why it's so complex. That's why you need a really good lawyer. So we were talking about, we talked about bare trust, implied trust, resulting trusts?
Resulting trusts is, I didn't realise I was going to get a little trust quiz. I love it. So a resulting trust is where maybe there's been a provision, it could be in a will, it could be in a trust document. Yeah. There's been a provision of some kind to say, I give my interest to Ben. So let's use Ben again. Yeah. But Ben has died. Yeah. Before I have died. So my will maybe says I give everything to Ben. Yeah. And in that situation, Ben passes away. There's no provision in the trust document or the will that says where that interest goes if it's not to Ben. Yeah. If I'm still alive, if say it's a trust during my lifetime, then it would result back to my estate because there's nowhere else for it to go.
Yes, of course, results back. So, that hedgehog, if Ben didn't get it and he wasn't with us, might result back to you.
That's right.
It would result back to you. It'd be a resulting trust.
Yeah, because we've run out of beneficiaries of that trust. Yes, so we've run out of people who can possibly benefit. Yeah. So it comes back to me.
Other trusts, have we...
So
common intention trust?
Common intention, oh my God.
I feel that and constructive trust, are they interchangeable terms?
Not strictly, but they often are used interchangeably.
I find that judges use different phrases.
They do.
What's a common intention trust?
A common intention trust is where, again, it's maybe not written down. Yeah. And so there's been no legal agreement, written agreement between the parties, but we can see that what they wanted to achieve. Yeah. And that could be a verbal agreement. As we know, contracts can be verbal, they don't have to be written. Yeah. Same as trust, they can be verbal, they don't have to be written. Yeah. This is where we started sometime before we went on this canter. So they can be, and a common intention trust often comes up in family cases when I'm talking about disputes about property. There was a common intention that we would share this. Exactly. And one of the parties says no. Or we agreed I'd pay half of the mortgage on the basis that I would get an equitable interest in the property, for example. Yeah. Exactly.
Common intention, constructive trust. I think,
within family law, they're pretty much the same, it. I would say.
So that's an interesting...
Constructive trust can be anywhere else.
So this is an interesting thing, isn't it? So in family law, as I was saying earlier, constructive trust will mean something. Yeah. Whereas perhaps in wills, it might mean something else. You'll have a different meaning for constructive trust. Am I right?
More within maybe more corporate situations. We've seen examples of constructive trusts where the court really, at the time of maybe an agreement not being written down properly or it being written down in a way that's not actually reflective of the situation, the court has constructed for want of a better word, constructed a trust around that situation to find what they think is fair. Because the thing that trusts really come back to is equity, which is fairness and justice. Yes. And that's the other element of this area that really gets me. Yes. It's like, we have to be just.
Yes. I can see that. And so galloping through trust, and so I hope, I don't know if everyone's completely lost or switched off, or anyway, we've had a good time.
This is really boring for everyone. I don't know.
No, I had to redo trusts at bar school. Really? I didn't really pay attention, and so I spent a whole summer just looking at trust. Yeah. Hence my sort of, my memories now. So I think I know more about it because I just had to redo it all. I didn't really have any idea about them at the time. Yeah. Of course. And obviously they come in financial remedy where you might have, let's say a husband has created a trust and a wife is saying, but that's really money that I want shared. Yeah. So that's a big area, isn't it?
It is a big area. And I mean, at that situation, that's when you get a real complexity where maybe the family court in itself has a lot of powers in that situation to look through certain trust relationships.
Yes.
So a husband might have a trust, but the family court says, in reality, this is what maybe we'd call a sham or a front, or really just a way to get assets out of your estate.
Yeah.
And really you'd be looking at so much circumstantial evidence in that situation. So it might be when he set up the trust, what's in that trust, what the trust document, if there is one, says about what's allowed to happen, but also whether there are any supporting documents to that trust document, something like an expression or a letter of wishes, which might write down and tell the trustees what he really wants to happen. So there might be...
Oh, just stop you there. So say there is a trust and so let's say the husband's a beneficiary of the trust and there's £1 million in it and nothing's been ever paid out to him, but there is... you've got a letter of wishes by the settlor of the trust. What if the husband's created the trust himself?
So if he's the settlor and the beneficiary, that's starting to look a little bit
Shammy.
What we call a sham, which is just you're just giving it to someone else.
But let's say it was
really
left to him by his father. Let's say it was set up by his father, and money was put in trust. And let's say he's never had any benefit of it, and let's say there's two beneficiaries, him and his brother.
Yeah. We've actually come across that situation within the firm before, where the situation was such that it was a blended family. So dad was on second marriage. He had set up a trust where new wife couldn't benefit, but their 5 children are potential beneficiaries in equal shares.
Yeah.
The family court, during one of the beneficiaries' divorce, decided to say, do you know what, we just have to allocate a 20% share of this trust to her so that, again, we can just deal with this as fairly as possible, even though that trust had never been distributed to her, had never received anything. But it was a very, very, very high value trust.
Yeah.
So the family court
imputed that she was going to get that.
Yeah.
That's really
but there was no guarantee.
No.
There was no guarantee because it was discretionary trust.
And was that fault? I mean, was that settled, or was that the feature and the judge made that decision?
So that was, I think it settled outside of court in the end, but that was the indication that what the judge would do. So the parties then kind of came together to come to, again, the most fair division that they possibly could.
Yeah.
Whereas that in itself is a little bit unfair, because when we have something called a discretionary trust, we have maybe default beneficiaries. So those 5 individuals could be, as a default, that's what they're entitled to.
Yeah.
But the trustees don't have to follow that.
Yes.
They have discretion to say, actually, one of those beneficiaries can have 80% and the others can all get 5% each.
And would I be right in saying that someone can put in and that it's a discretionary trust, almost to kind of get...
To muddy the waters,
as it were.
Yeah.
So the trustees have a discretion. Let's get my hedgehog back.
Yeah.
I've got a discretion. I've been given a discretion whether this hedgehog is shared. There's 3 possible beneficiaries, Ben and his 2 brothers, let's say.
Yeah.
That I'd have a discretion then. And then, but the court might say, I know that the court, I always say this, we as lawyers, we try and make things hard, simple, and that's really kind of our job, isn't it?
Yeah.
And so judges will want to make that as simple as possible, but it is quite tricky, isn't it?
It is. It's very tricky.
And someone, they might get that wrong, because it might genuinely be a discretionary trust for the hedgehog, which I'm going to put back now. There's so much we can say about trusts, but I don't want to just keep you there. I know that you'd love to talk on, and of course, if anyone wants to comment or send us a message, I'm sure you could just give some general chat about trusts, or come and see you, of course, if they've got a family case with trusts in. I know the other areas you deal with are powers of attorney. So tell me, what is a power of attorney?
A power of attorney is where you are nominating someone called an attorney.
Yeah.
The trick here is that they don't have to be a lawyer. So a lot of people, when they come to talk about powers of attorney, think in the, especially in the American sense of what an attorney is, they think, it has to be a lawyer.
Yeah.
But it doesn't.
Yeah.
It can be anyone at all. Anyone over the age of 18 who has mental capacity. We come back to that idea.
Yes.
So you're appointing another person, an attorney, to act for you if you are unable to act for yourself anymore.
Yeah. So can I throw in there, do we know what is the meaning of attorney? Because it seems to be like representative almost, doesn't it? Because that's attorneys used as a lawyer in America. And as you say, that can be confusing because we use a lot of American English.
Yeah.
But it seems to me that really it's sort of representative for you.
I think so, yeah.
They've got all the powers. Agent. Yeah, it's an agent, isn't it? Attorney.
I mean, there's so many different terms around that area. It could be attorney, agent, nominee. There's so many different different terms.
So acting for the person.
That's right.
There's got to be some, you want to pick someone that you do trust. And
absolutely.
To do the right thing.
That's vital. The trust relationship is absolutely vital in a power of attorney. So I mean, it's very common for, if we're spouses, each other, and then maybe their children or nieces and nephews, people who are close to them and know them really, really well. So this is more in the context of what we call lasting powers of attorney.
What sort of powers of attorney are there?
So there's broadly two different types that we deal with most frequently. A lasting power of attorney is kind of what it says on the tin. It lasts until you die.
Okay.
So it endures.
Can you ever revoke it?
You can.
You can. But if you don't revoke it, it will just continue on.
It continues on. Exactly that. So you put it in place and it will continue on even if you lose mental capacity, if you change your address, if you change your name, all of these different things, it continues on.
Yes.
You can revoke it. It has to be done by deed. But you can do that.
Deed being a signed document with witnesses, basically.
Exactly, signed in the presence of two people. Exactly that. So that's the first type of power of attorney.
And is that also called an enduring power of attorney?
It used to be called an enduring
it used to be called that. Now it's called a lasting. They try and make things simple.
But then they change the name and everyone gets confused, literally.
So it was previously an enduring power of attorney. Now it's called a lasting power of attorney.
Yes,
I hope everyone's happy that
I really hope they don't change it again. It would just be so annoying. But enduring powers of attorney that were made before lasting powers of attorney came in still work.
Yeah, they're just been called a different name.
Exactly.
Yeah, okay.
Exactly. And a different form, of course.
Okay.
Because that's what we need.
Yeah.
So you've got that type of power of attorney where it lasts as long as possible.
Yeah.
And then you've got something called a general power of attorney, sometimes also called an ordinary power of attorney.
Okay.
And that is where most frequently, again, you would appoint someone to act for you in a short-term situation.
Yeah.
So it might be you are going on a 3-month trek in
Mongolia,
somewhere wherever,
remote.
somewhere very remote where you're probably not going to have much signal and you're going to be off for a while. But you also know, I need to sell my house, say.
Okay, got it.
So what you might do is put a power of attorney in place that's just for that purpose.
Yes. It's kind of confusing though, because it's called general. And so that to me would think, you can generally do anything you like with that money, but it's not that.
It's not that. So it is nice and confusing that there is something called a general power of attorney that can't really always be used generally. It can be. So you can have a short term for 12 months. You can deal with my financial affairs, for example, or you can deal with all of my money in and out of the specific bank account, something like that.
Yeah.
It's adaptable. Which is maybe that's why it's called general, because it can be used in lots of different situations.
Yeah. So you don't have to just say it's specific.
No, you don't have to. That's just where we see it most commonly. Is to complete the transaction on a property where we want to have complete control over everything we have when we come back from our trip, for example. So it can be used. It's a bit more adaptable, I would say.
And what sorts of powers? I mean, is there a medical one, or is there a financial one, or is it all the same?
Yes. So looking back at lasting powers of attorney, there's two different types.
Right.
One is exactly like you say. One is medical, and one is financial.
Yeah.
And when clients want to make both, you've got to really think about who you appoint under each document. It can be different people, so they're completely separate documents. You can have one set of attorneys for finances, one set of attorneys for healthcare.
Yeah.
They can be different, but they're going to have to work together, especially on big decisions, for example, whether you go into a care home or whether you receive care at home. That's a big expenditure, but it's also really about your well-being as well.
Yeah.
So we're looking at property and financial affairs is one document, and health and welfare is the second type of power of attorney.
And if people, let's say something happens to someone and there is no one to take over, what would you do?
That situation does happen. It's really, really sad. And so if someone maybe loses mental capacity, but they don't have a lasting power of attorney in place, that's when we have to apply to a special court called the Court of Protection.
Yeah.
And in that situation, it is quite a lengthy process. A lot of detail is needed. Yeah. A lot of different forms are needed to be submitted. There's court fees. Yeah. There's often legal fees as well.
Yeah.
And this goes to something I tell my clients so much, which is please just make a lasting power of attorney, because especially when you're getting a little bit older, obviously unexpected things can happen, but when we're getting a tiny bit older, thinking about towards retirement age, I should really get lasting powers of attorney in place sooner rather than later, because if something did happen unexpected where they couldn't make their own decisions, say they're in a coma, something like that, there's an accident, someone is unconscious, they clearly don't have mental capacity to make decisions. Without a lasting power of attorney in place, no one can access your bank account.
So could someone make a lasting power of attorney, but could it be only come into operation if something like that happens?
Yes.
That's interesting.
That's true. Yeah. That is exactly something that can happen. So health and welfare only ever comes into operation when that person can't make their own decisions.
Right, okay.
Property and financial affairs, you can choose.
Okay,
so it can
that
be
makes sense.
either only when you can't make your own decisions, or as soon as it's registered with the Office of the Public Guardian. So it has to be registered with that public body, the Office of the Public Guardian, to be legally enforceable.
Yeah.
Very complicated.
It's a pretty smart thing to do, isn't it? And also, let's say, if you're getting older, it could be one of your children that, you have trust with, and, you're still going to be able to do anything you want to do, but then they wouldn't have that problem if something were to happen to you, and
it's
it might be
ready to go.
And it's presumably quite expensive, is it, one way or another?
Yes. So putting lasting powers of attorney in place itself, that's not very expensive.
No.
So the registration fee with the Office of the Public Guardian is £82 per power of attorney.
Yeah.
It's pretty insignificant for most people, luckily. The Court of Protection, however, the court fees alone are thousands.
Yeah.
Honestly, to have, especially if it's going to a hearing, is a lot of money.
And
then legal fees as well.
Yeah. And so is that because judges have to be really clear that, if you're stepping in someone's shoes, that's all done properly, and there's quite a lot
got to notify certain people. There's like numbers of people you have to be made aware that you are trying to assist, because you do see it very frequently where someone is poorly, maybe it could be a matriarch or patriarch of a family, and then you've got maybe siblings or nieces and nephews and grandchildren all having their own opinions on what's in the best interests of that individual.
Yes.
And where there's conflict, the court has to make a decision about who should act for them. And when the Court of Protection does that, they appoint someone called a deputy. So it's different from being an attorney, and it's usually a less it's a more constrained.
And is that person usually a lawyer, the deputy?
It varies.
Or could it be anyone?
It varies. Where there's a lot of disputes between different family members, it could be what we call kind of an independent deputy, which is usually a lawyer.
Yeah.
And you need some pretty special qualifications to really act in your client's best interest for that. So you can do extra training as a lawyer to become a deputy.
Tell me, do you get involved in cases where you find out there's been an abuse of a power of attorney?
Yes, sadly. I would say for every year I've been in practice, I've had at least one of those situations come along. It is sadly quite common.
Yeah.
Where someone is appointed under a power of attorney and they start helping themselves a little bit. And I've actually acted for both sides of that situation. So I've acted for a client coming to me and saying, look, I'm one of the attorneys. I don't trust what my sibling or stepsister or mother or stepmother or whatever is doing because I'm seeing these suspicious transactions or payments on my dad's debit card, but he was in hospital at the time. Those sorts of things where we don't know what is happening with that money. And alternatively, I've acted for someone who has come to me and said, I have a gambling addiction and I have been taking my dad's money.
Oh dear.
And I've been through therapy now. I need to rectify the situation. That one was gut wrenching. As I'm sure you can imagine. That one, it was again it really tests you. And I mean, I'm sure you had situations like that, especially in criminal law, where you see someone and you think, my heart goes out to you because you're not well, but you've really acted wrongly. So let's try to rectify this as best we can. So it is a common situation where maybe a child under a power of attorney has been caught taking money they shouldn't have done from a parent, maybe by their sibling. If they can, they pay that back during their lifetime because it's what we call misappropriation of that money or those assets. Alternatively, sometimes there's a settlement during the probate. So it's very frequent that if you've got two attorneys, two kids, then your estate goes 50-50 between them as well. That's quite a common situation. And it might be that the person who has financially abused their parent has less from their estate and it sort of paid back, as it were, during that probate process. So I've acted on all of those different areas, and it's a really upsetting one.
And is there a possibility of a criminal side to that?
As a possibility, very, very infrequently do families really want to go down that route. I would say it's as long as it's settled and someone could admit their wrongdoing. Usually
it's quite delicate, isn't it? And I'm guessing again it's you're harnessing all your people skills as well as your intellectual skills.
Absolutely. And you've got to be a real empath in that situation. You've got to be able to say, well, you know, and you've got to be able to deliver bad news in an empathetic way. And that's what's really tough sometimes, is you're saying to your client, look, you might know in the back of your head or know so strongly that your sibling took 100,000. We've only got evidence of 40. So what do we feel about this? Are we going to go for the full 100? Or are we going to settle at 40? Or are we going to try and have a midway? And you know, it's building that relationship with that client and saying, look, I'm on your side. I'm here to help. But it's your decision whether we go down the route of maybe litigation and incur a lot of fees and incur a lot of time and stress and all of the rest of the things that come with litigation, or do we try to go for a settlement? Do we mediate? Do we do what we can to just draw a line under the situation? And it's because it's never just about the money.
No.
It's the feeling behind it.
Yeah.
And that's what makes people really go for these situations sometimes. So it's a
money
really
and family
area.
It's a bit of a mix. And tell me, is it important to have a will? Because obviously you deal with wills. Why is it important to have a will?
Why is it important to have a will? Well, it's very important to have a will, but I think everyone knew what I was going to say. So it's very important to have a will because there are a set of rules that apply to someone's estate if they don't have a will. And that's something called the intestacy rules. And so if someone dies without a will, they're called intestate. If you want something different to happen to your estate, then you should make a will, because then you can specify, no, those, again, default provisions in the law don't apply to my situation. What I've written down in my document applies to my situation.
It gives you more control, again, a bit like the power of attorney side of things.
Exactly. And I mean, those intestacy rules...
Not that you're not going to be there, but, you know, prospectively, rather than perhaps your children falling out.
You know, it's your life, it's your whole entire, it's your estate, it's everything you own. So it's your property, it's your bank accounts, it's your premium bonds, it's any shares you own, it's your personal possessions. And if you have any specific wishes whatsoever about any of those items, and show me someone who really doesn't care, they should be looking at making a will at least. I think statistically less than half of the adults in the UK still don't have a will, which just is quite mind-blowing when you think about it.
And why do you think they don't make a will?
It's not the funnest thing to think about, really, is it? It's I think a lot of people are a little bit avoidant about that topic. I have a lot of different clients who approach that topic differently. Some people say, look, I'm really anxious about this. I don't want to be here, but I need your help. So they're really taking a lot of emotional strength to get to even just have a conversation with a lawyer about their will. Other clients just have really dark sense of humor about it and just make all the jokes. And you look at that and you're like, I know you're feeling a certain way, but I'm going to let you do this because this is your process. And other clients are just really direct and just say, this is what we're going to do. They've just cut off those emotional ties.
So it's always bringing up some kind of emotion.
It's always something. I mean, for me as well, I talk to my clients every single day about death, sadly. But when my mum was making her will, I didn't want to hear it. I was like, no, I don't want to talk about it. But so even someone who just deals with it every single day, you just can't necessarily disassociate in that way.
And I really... I'm going to express a view on this, really. I really think people need to see a solicitor for a will because, in fact, my mother made her own will and she's just one of those contrary people and it was all wrong when, so it's caused all sorts of problems. But she was just, wanted to do it herself and went to W.H. Smith's and did it and kind of worked out in the end, but it did mean there was a court process. It's just a bit silly and I don't think she expected. And then apparently there was another will that someone told me about, but we never found that one. So, doing the will, going to a solicitor, I think is best. That's what you do. You're trained. And it's not that. It's not particularly expensive. I think solicitors give an amazing deal on this. Yeah. That you'll give a very professional service.
That's right.
And then you'll advise on, where that should be kept. And,
exactly.
And, we were hunting around. I was phoning all sorts of people, thinking back where it would be.
Yeah.
And I was an executor, so it was important. I had to go through all of that.
Those inquiries.
Because if the money had gone out to the wrong beneficiaries, then
that's on you.
That's on me. As an executor.
Exactly.
So
no,
don't
that
cause a
professional
muddle.
service is so important. The W.H. Smith wills at this point, I think cost £50, something like that.
Yeah. No offence to W.H. Smith. I mean,
not at all. But I mean, I have been through 7 years of training for this. So it might be a slightly different situation. And I mean, in terms of when we give our professional service for a will, yes, you get a draft. You can look at that draft, make amendments,
Yeah.
You also get a review of your inheritance tax position, which is very important.
That's a big issue, isn't it?
For a lot of people, absolutely.
It's not just that getting what you want. Your people that you love are going to get more money because you're going to hopefully avoid tax.
Have thought about it. Exactly.
Yeah.
I mean, some
Unless
people
you want to give tax to the government.
People have such different views. Again, people say, do you know what? I've worked hard.
Yes.
My kids have to work hard as well. They get what they get, and the taxman gets what he gets.
Yes.
Fine.
Which is fine. Yeah,
Right.
but at least
that's fine for some.
be thinking about
but that's not fine for others.
Yeah.
Other people would rather give to charity or would rather make some more gifts during their lifetime to their family so that their estate is maybe a little bit smaller by the time they're taxed. And there's lots of different rules around that, which I'm not going to get into right now. But if anyone wants to ask, I'm happy to
you're
help,
the expert. You're the expert.
They get that review, and we get a little bit of a kind of little bit of estate planning side of things where we think about this pot goes here, this pot goes there. But at the end, you have your will signed properly and checked by a solicitor as well, because if a will isn't signed properly, it's not legally binding. So it's similar to a deed where you have to sign yourself as the person who's making the will in the presence of two witnesses. So there's been lots and lots of case law around wills being signed properly and executed correctly. If it's not signed properly, it's not valid. So you make sure it gets signed
Which is
properly.
the worst thing, isn't it? Because imagine doing all of this and it doesn't end up being valid, and people
that in itself is going to go to court as well, isn't it?
It's going to go to court, and then those cases, I mean, are just so sad that people are bickering when
it's a lengthy process. It's stressful. It's making family relations that are already strained because everyone's grieving so much worse. Those sorts of contested probate situations really do bring out the worst in people, and it's really sad to see because again they attach that emotional feeling to the money because that's all there is to really fight
that's all
over.
there is.
That's all that's left.
And it's always said divorce affects your will.
It does.
What does that mean?
It does.
So importantly for people going through a family case.
This is it. So in both in relation to if you've made a will during your marriage or if you haven't, it's very common your spouse will benefit from your estate if you're still married. So if you're separated but still going through the divorce process.
Which can take a long time.
It can take years. We know this. Your spouse may still be the primary beneficiary of your estate, either under the intestacy rules or under your will that you made 20 years ago maybe. So making a will to protect certain assets during the divorce process is really important. If you don't, and you've got a will in place, and say you've got, spouse and 2 children, leave everything to spouse in the first instance, 50-50 between the kids in the second instance. So in that situation, if you didn't make a new will during the divorce process, upon the decree absolute or final order being received, your spouse is treated as having died that day. So they no longer benefit. But that is sometimes at the end of a very, very long process. So if you don't want your spouse to benefit during that process, you need to think about making a new will once you're separated and going through that divorce. Obviously, heavily caveat that with a lot of the time, especially if there's maybe one financially more wealthy party, you might have an obligation to leave something to your spouse where there's maybe not a financial settlement just yet, because that spouse will be still reliant maybe on a financial settlement of some kind, be it a lump sum, be it maintenance. So there might be
a claim against
there
the
might
estate.
be a claim in that situation. But if someone came to me and they're right at the beginning of their divorce process, we would have a very in-depth discussion about, well, what do you own? What assets are at stake here? What's likely to happen at the time of a divorce? And so what can we do to help put your mind at rest and put something in place that should the worst happen during the divorce process, your estate is not going to be in flux or contested for years.
Which, is not going to be great. And then once you are divorced, that's the time to make a new will then, isn't it, as well?
Yeah.
And why is that?
I mean, I tell my clients to at least review their will every 5 years or every time something big or significant happens in their life.
Yeah.
And so that could be every 2 years, that could be 10 years, but you've got to just review it and make sure it's still fit for purpose, because it's a document you can change at any point before you pass away, again, as long as you've got mental capacity. Yeah. So if someone, gets divorced, their spouse is treated as having passed away before them in their old will, and everything goes 50-50 between their two biological children. If they are with a new partner, maybe they're cohabiting with someone again, but not married yet, something like that, that's going to be its own complicated, wonderful but complicated situation that we're going to have to make some provision for. So at the moment, I'm dealing with a cohabiting couple where the gentleman is still going through his divorce process, but he's living with a new partner. They're talking about marriage. They're talking about who receives the property, but they're living in her property, so it wants to go to her children. These blended family situations get more and more complicated, but they also get more and more common these days. So you've really got to be well versed in dealing with these situations in this area of the law, because it's just vital.
And for Family Law Cafe customers that are with us, you're doing a special package for that. So we are doing your wills package, so the special rate. So that's all great. That's how we work. Special discount for us. Because you love us.
Exactly.
And so in terms of wills, trust planning, anything else that you deal with that touches on family law that you do in your day-to-day?
I would say not much.
Those that was just me covering myself. Those are the areas that touch on family law.
Yeah, I would say so. Yeah. I would say so.
And I also, with wills, I think again, people don't want to think about organising their divorce. Yeah. They don't want to think about organising their, what's going to happen when they pass away. Yeah. And so if you are going through that transition, it is a good time to kind of take stock and try and document things. And if you're in a relationship where you're not married, you need to know that you're in a sort of area that's really legally complex. There's no set rules in this country. I mean, there's discussion about that will change.
And there's a law commission review, isn't there?
There's a law, but there was a law commission review before I even qualified.
Yeah.
I mean,
it doesn't mean anything
been talking
really
about it for years, and so nothing has actually changed.
Yeah.
So thank you for talking about all these things. I hope that, I hope between us we've clarified a few things and not made it more complex, because obviously, I'm trying to make it simpler for people, but it is a really complex area of law. And again, to go back to, then hopefully you're making real change for people and hopefully enjoying what you do.
Yeah, absolutely.
So thank you so much.
No, thank you so much for having me. It's been a pleasure.